Hi, I'm here to pick up my son Milo.
There's no Milo here.
Who picked up my son from school?
Streaming only on Peacock.
I'm gonna need the name of everyone that could have a connection.
You don't understand. It was just the 5 of us.
So this was all planned.
What are you gonna do?
I will do whatever it takes to get my son back.
I honestly didn't see this coming. These nice people killing each other.
All Her Fault. A new series streaming now only on Peacock.
We all love a legendary comeback, and Degree Original Cool Rush is back and better than ever. Cool Rush isn't just a scent, it's a movement, a fan favorite that delivers bold, fresh vibes and all-day sweat protection. Whether you have a man that spends hours in the gym, heads into the office early, or is just trying to stay fresh on a long day, Cool Rush has their back. Head to your local Walmart or Target and grab Degree Cool Rush, the fan favorite scent from the world's #1 antiperspirant brand.
How long did you know this guy?
For about 6 weeks, but other employees of mine knew of him, and it was
How'd that work out for
devastating.
you?
Not well.
Right.
Not well.
This is the plaintiff, Marion Coral. She says she purchased a truck for a young man who worked for her, and he ended up taking off with the vehicle and was never heard from again. The guy she bought the car from, the defendant, made himself the lien holder. Therefore, he's now 100% responsible for her loss. That is why she's suing him, here and now in this courtroom, for the $5,000 she's definitely owed. This is the defendant, John Mazzone. He says the plaintiff told him to put her employee's name on the title of the car, and he told her once he does that, the cars are employees and no longer hers, even though she was paying for it. She told him that was fine, and now all this time later, she comes after him and sues him because her employee took off with the truck? Oh, sorry, but she's plumb out of luck. He's accused of making a big mistake.
All parties, please raise your right hand.
What you are about to witness is real. The participants are not actors. They are actual litigants with a case pending in civil court. Both parties have agreed to drop their claims and have their cases settled here before Judge Marilyn Milian in our forum, the People's Court.
Be seated. Come to order, please. Litigants have been sworn, Your Honor.
Thank you, Douglas. Marion Corral?
Yes.
Okay. You are suing Wheels Unlimited of Patchogue, represented here by Mr. Mazzone, for $5,000 that you say you are out on a deposit you put on a car from his dealership and on the purchase price of a car that you bought from his dealership. Tell me what's going on here, because this is rather confusing.
I had an employee that worked for me, and he, for a short period of time, and he lost
What kind of business?
I have a delicatessen in East Patchogue.
And he was an employee of yours at the delicatessen?
Yes, for a short period of time. And there was a tragic accident, and he lost his brother and the car. So not having transportation, we were driving, and other employees were driving him back and forth. We decided to help him get some transportation so he can be on his own. Prior to me doing that, I went to my attorney, which I have a paper from, because I wanted him to draw up something for me to protect my interests, like how I get paid back or something like that. He said to me, Marion, nothing supersedes being lien holder on the title to protect your interest.
I'm sure the attorney told you to get the loan in writing as well, right?
Right. Yes.
So can I see that?
Oh, I don't have that with me. We wrote up a program, and he was going to pay $250 a week for the car until I was paid in full.
Okay, so go on.
And then what had happened was, after about 3 weeks, he skipped on me, and I didn't see him anymore.
How long did you know this guy?
For about 6 weeks, but other employees of mine knew of him, and it was
How'd that work out for you?
Not well.
Right.
Not well.
It's not like this guy is a 20-year employee of yours.
No,
this connection
no.
Okay, so go on. So then what happens next?
So I called the defendant up, and I asked him, how do I proceed?
How did you hear about the defendant? Like, how did you pick him?
When I would drive Joe to work, we would pass Wheels Unlimited, and he said to me that he bought a car there once before, and that he had lower priced cars and more affordable things. So he said maybe we could stop in there.
Okay, so you call him?
Well, we went to the dealership with Joe, and he picked something out. And I gave $380, and then I gave the next day $1,000. You know, at that time.
Who were you doing your dealings with at the defendant's place? The defendant himself or someone else?
The defendant,
okay,
I believe.
Go on.
And then I put the rest on my charge, which I think was $36.38, the balance of the car.
Why would you guys take a credit card for most of the purchase of a car?
We normally don't.
Yeah, why did you in this case?
Well, she was a local business person, and I just didn't think there'd be a problem.
Go ahead.
So I called up the defendant, and I told him that this guy took off, and how do I exercise the...
Wait, but what does took off mean?
I didn't see him. He didn't come to work after about 3 weeks.
Right, but everybody who works at your deli knows him and vouch for him. So where is he? Do you know where he lives?
He was living with his father at the time.
Right, but did you go search him out?
Yes, I did. And that's why I have Mr. Montalbano with me.
And who is he?
And Tommy Montalbano is a friend of mine who's in the auto business. And also, I asked him
in
maybe...
the auto business, why don't you buy a car from him?
His are much more expensive.
Oh, what kind of friend?
And I have, yeah. And I have.
All right.
But so we were hoping that maybe Tommy could assist me and figure out what to do next, because quite frankly, I couldn't believe that he took off.
Okay, so let's rewind 1 second.
Yes.
Just stay with it. All right, so you're at the dealership and you're striking a deal to buy the car and you put it on your credit card.
Right.
My question is there any other discussion between you guys?
The dealer and myself?
And you.
Oh, I said to the dealer that, you know, I took him on the side and I told him that I was a little concerned about, doing this. And I said that I wanted to make sure that I protected myself and be lien holder on the car.
Okay, so tell me the discussion about you being lien holder.
Okay, well, I told the defendant that I went to my attorney and that he told me that I should be a lien holder on the title to protect my interest.
Okay.
Because I really didn't have...
And what did the defendant say to you?
He said that he would take care of it. And the defendant even recommended to me, he said, why don't you if you're so worried, why don't you put the title of the car in your name? And I said, I didn't want to put the title in my name, because God forbid something happens. I didn't want the exposure, the liability. I said, I own my home, I own my business. So I said, I really put everything in Joseph's name, just put me as the lien holder, because I did not want the liability.
Okay. And in fact, what happened is that when the title comes back, you are not the lien holder, he is the lien holder.
Yes, ma'am.
Why did you list yourself as a lien holder if the car was paid in full in the form that you accepted?
For exactly the reason what happened. If I take a credit card for a purchase and it's not going in the person's name that's on the credit card, I put a lien on the title of the vehicle.
Do you tell people you're putting a lien on a title that has a zero on a car purchase that has a zero balance?
I tell them that when I...
Did you tell her you were making yourself lien holder?
Yes.
Did he tell you he was making himself lien holder?
No, Your Honor.
Did she tell you she wanted to be a lien holder?
No, she did not. She told me at no time she wanted to be a lien holder.
Okay, but I have a letter from her lawyer saying he did advise her to do that. That doesn't mean she followed her lawyer's advice. But, she's clearly has some concern over this that causes you to say, well, why don't you just put the car in your name, right?
At the time when her and the purchaser was in my office, I told her right in front of Joe, I said, if you're going to buy the car for Joe, you should title it in your name.
Well, but hold on. Didn't you think it was a gift? Or you knew there was a loan agreement between the two of them?
I thought it was a gift, but I wanted...
You didn't think it was a gift?
No,
because if you think it's a gift, there's no reason for her to title the car in her name. That's a lie.
I thought it was a gift, but I also knew she was buying it because the boy worked for her. So I know how gifts go. Sometimes gifts are Indian gifts.
No, here's how gifts go. They are a gift. Okay. What ends up happening is here, when the guy skips on her and stops reporting to work, she panics, you call him, right? And you say to him what?
How do I activate the lien that's on the title?
In my name.
In my name.
And he says to you, I don't know what you're talking about, I didn't put a lien in your name.
He said the lien for the title is in my name, his name.
Right.
So I said, why would that be? And he said to me, because that's what I did. So
then you say to him, well,
I said
repossess
to
the
him-
car because the guy's not making payments, he's not working the debt off, he's not there. And he says, I can't repossess the car because he hasn't done anything to cause me to repossess a car. I'm paid in full for my car.
But, Your Honor, I might also want to add that there's no way for me to put a lien on a vehicle in her name. It's just impossible.
Why?
Because she doesn't have a lien filing number with DMV.
Why?
Because motor vehicle, you need a lien filing number.
Then you get a lien filing number. You're not.
She would
Let me just stop. You're wrong about what you're saying.
No, I'm not.
That there's no way for a lien to be placed in her name. But if I believe her that she told you she wanted a lien, and you just ignore her, you can't then come later and say, "Oh, it was impossible to do what she wanted anyway, so it doesn't matter that I didn't do it."
Your Honor,
I'm fascinated by all of
Right.
this. I am trying to figure out why you are suing him. I know why you're suing him, because you say you made it clear to him you wanted a lien and he didn't follow your wishes. So when you find out that the lien's in his name and he tells you, I can't do it, I'm not going to repossess the car, I'm not owing any money. You then decide, well, watch this. Now you're going to be owed some money. So you call your credit card company
Yes,
and
ma'am.
you charge back the $3,800.
I called my credit card company and told my credit card company what was going on, and
Yeah, I
that
know.
I
So
had
you
a
charged
problem
back
with
the $3,800.
with a merchant, and they advised me. They said that they would give.
Ma'am, did you charge back the $3,800?
Yes,
Right.
Your
So then
Honor.
now you are out $3,800. So what do?
after about probably about a month, going back and forth to the credit card company waiting for a decision, I spoke to Joe and I told Joe that.
Wait, how'd you speak to Joe? I thought Joe went off to.
I called him on his
Tahiti.
number. I called his phone number.
Oh, you called a phone number and you got Joe on a phone number. Looky here. Okay. And so you got Joe, and what did Joe say?
I spoke to Joe and told him that Marion Corral had stopped payment and charged back the credit card. I'm going to have to pick the truck up. But I said, at this point, you'll probably get it back, but I can't guarantee it. And he understood.
Why are you so sympathetic to Joe?
Because I seen how she treated Joe.
What do you mean?
She treated Joe like he was her slave.
What are you talking about? According to you, she was giving Joe a $5,000
Right.
gift.
Right. But
All
then,
slaves should be treated like that.
I guess so.
So I don't get what you're saying.
Well, because I came into the deli and she was ordering around and barking around, and the guy was, she was just treating him like she owned him.
I don't get it. But your version is that she wasn't loaning him money to buy a car; she was giving him a car.
Correct. Yes.
So you tell Joe what? Why don't you just repossess Joe's car?
About a month after Citibank charged back my account, I repossessed the car.
All right.
Well,
And then what happens?
At that point, Mr. Tommy Montalbano came down to me, yelling and screaming, and said, I got to do the right thing by Miss Corral and stuff. And after a while...
What was he asking you to do?
To give her the repo the truck and not give it back to Joe. Well, I had the truck already at that point, not to give the truck back to Joe because Marion's already been through this with him. She purchased a car from him for a pizza guy, and he left.
Wait, is that true?
Yeah.
Yes, it is, ma'am.
A guy who worked for you?
A guy who worked for me.
Okay, go ahead.
And I explained the whole story to him, and he calmed down. I said, look, this is between...
What did you tell him? Wait, let me ask you. What did he tell you?
He had told me that he knew Joe, and he said that he was going to probably get the car back to him. The title and everything is in his name, and he,
Did you and he talk about the lien or lack thereof?
Yes.
What did he say?
He had said, I said that why did you place yourself as a lien holder, and why didn't you place Marion as the lien holder? And he said that he was protecting his interests. I said, what interest are you protecting? You were paid in full.
See, here's a problem that I'm having. I'm having multiple problems. I don't necessarily trust him. But I also don't trust that Marion's a really good businesswoman who makes decisions based on, okay? I think she makes decisions based on her heart.
Not my head.
That is correct. I don't know what discussions took place that day, but let's assume for a moment that the discussion that took place is make me lien holder. I'm trying to understand why he wouldn't then just make both him and her lien holder.
Can't do it.
Why can't you?
She doesn't have a lien filing code. In DMV, New York State, you need a lien filing code.
Okay, just stop. Just because someone's not doesn't have a prior number doesn't mean that they can't be a lien holder out of time.
It's possible for her to go to DMV and put a lien on it, yes. Not for me to do it for her.
I don't trust you as far as I can throw you. I think that you are a self-interested individual. I think that you were friends with Joe, so you're totally on Joe's side.
I'm not friends with Joe.
Stop talking. I'm not inviting you to speak.
Welcome back to the People's Court. Harvey Levin here. So, you had a business employee after 6 weeks says, hey, Can you loan me money for a car?
No way.
Why?
Because I've only known you for 6 weeks.
Okay, well, what's the problem? What's the special problem when it's an employee that you're loaning it to?
You can't trust somebody you don't know. You can't get...
Anything special, though, about an employer loaning it to an employee?
The fact that I'm owning a business and they're coming in and then I'm supposed to trust them? I mean, this is...
Well, no, they say that they're really hard up, but how are you going to keep...
But I'm the boss here, and then we have a different relationship going on here. You're an employee of mine, and we need to...
So the answer is no.
The answer
Gotcha. Going inside the courtroom.
I think that you were only, I think it's entirely possible that this lady followed her lawyer's advice and asked you for a lien. I think that you wanted to put your own lien on there, and I don't think you told her you were putting a lien. I think you put a lien on there just in case the credit card payment didn't go through. Having said all that, here's where I'm having the legal difficulty in what you are doing. When you're in court, you have to be able to say, Judge, he needs to pay me $5,000. Why? Because I'm out the $5,000, thanks to what he did. He didn't put a lien on, and now I can't collect against Joe. Do you see the part of that puzzle that's missing in court right now? It's the I can't collect against Joe part. That is one of the things you have to prove to make him pay you $5,000. You see? And that's the part you can't prove because you're not even suing Joe. I mean, you say to me, he doesn't have anything. Well, I can't just take your word for that. I mean, if Joe has a car, you understand what I'm saying?
How would I go after him?
Listen to me. According to you, you had Joe sign loan documents. You did have Joe sign loan documents, right? You're not lying.
Yes, I did.
Then what's the problem? What have you done in this lawsuit in order to show me that it's impossible for you to collect against Joe? Nothing. Because you didn't even bother to sue Joe. So here's what I am going... Now stop. We're done. Here's what I am going to do. I'm going to dismiss this case without prejudice. That means that after you sue Joe, bring him to court, and are unable to collect against him because he got rid of the car, has no assets or whatever, then you would be in a position to make him pay this. But you're not in a position now to make him pay this. No! That is what I am going to do. Okay? That's my judgment.
Well, Judge Millian does the plaintiff a favor and dismisses without prejudice, so come on in here. You were listening, right?
Yes, I was.
Okay. What did you hear her say?
I heard her said she was dismissing the case without prejudice and that I should go after Joe. But I feel they stole the car from me, the plaintiff, the defendant, and Joe.
Fine, Joe. All right. Head right down this way.
Thank you.
All right, so come on in here.
How are you?
Judge wasn't too happy with you either, but the law is the law, and so she couldn't rule against you.
Well, with Ms. Corral in business, you make decisions. Like life, you have to make decisions, you have consequences. She decided to loan her employee money, and then it became my problem. And she told me she didn't trust me, which is, I've never heard a judge say that in her life.
That's just an opinion.
Well,
Harvey?
I guess.
Okay, well, I got to say, this lady's absolutely right. You should never, ever, 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 ever loan money to anybody if you don't know them really well. And even then, you have to protect yourself by getting something in writing showing what is owed in writing. That'll do it for this case. Litigants for the next case on the way into the courtroom right now.
This episode is brought to you by eBay. Buying parts for your car? You'll know that will it work feeling. But on eBay, buying parts is different. eBay's free returns means if it doesn't fit, or if it isn't what you expected, you just print a label, drop it off, and get your refund fast. No haggling, no stress, and at least 30 days to return any eligible item. Millions of parts, free returns. eBay. Things people love. Eligible items only. Exclusions apply.
Shaq here, spinning fast-acting pain relief with Icy Hot. Ice works fast, heat makes it last. Icy Hot, you're so back.
This is the plaintiff, Julio Perez. He says he brought his brand new phone to the defendant's shop to have the cracked screen replaced, and the foolish guy crazy glued the new one in. Now his phone doesn't work properly. It looks like a kid in kindergarten fixed it. And he's suing the shoddy repairman for $631.99, the cost of a new phone. This is the defendant, Dowry Reyes. He says the plaintiff didn't want to buy a new and expensive screen for his broken phone, so he decided to buy a used one, which was much cheaper. The used screen had a small scratch on it, but hey, it was used. The guy freaked out when he saw it, called the cops, and is now suing him for a new phone? Sounds like a scam to him. He's accused of a poor screening.
All parties, please raise your right hands.
Next case in the docket, the plaintiff says the defendant screwed up a cell phone by gluing on the screen, but the defendant says the whole problem is the plaintiff is cheap. It's the case of a very sticky situation.
Thank you, Douglas.
You're welcome,
Julio Perez, you are suing CellSpot and OK Laptop Phone, represented here by Dowry Reyes, the manager, correct? Are you the owner or no?
Yeah.
You're also an owner? Okay. For $631.99, the estimate that you have obtained to get a brand new phone, because according to you, they botched the repair. Tell me what happened, first of all.
I had purchased a new phone just about a week after it came on the market. And 2 weeks later, I accidentally dropped my watch on the screen and it cracked.
Oh, what luck.
So I was asking people around at work. One of my friends told me about the defendant's shop,
Okay.
which I went there. And he told me to fix the screen will be $80.
Okay.
So he told me it will take about 30 minutes to replace it.
Okay.
So I waited there for 2 hours instead of the 30 minutes he said. Nevertheless, he attached the screen to the phone, and when he showed it to me, I could see the lights inside the phone. The screen was raised.
Raised.
Correct. It wasn't
Okay.
snapped on correctly. I confronted him. I told him this is defective. If I accidentally drop a drop of water, it will just go through the phone and damage it. So he said, well, I'll see what I can do. I'll order you a new screen, come back in about a week.
So you come back, and what happens?
So I come back, he had the new screen, and he worked on it for about 2-3 hours.
Okay. So you saw him try to what?
I saw him trying to force the screen onto the phone. The one he had apparently was too big. So then he calls his assistant and asks his assistant to bring the crazy glue. I was shocked. I'm like, I can't even watch this. So I walked out. I told him I'll be right back. So about an hour and a half, I come back. He had the screen snapped on the phone, but there were scratches on it. And also the functionality of the phone was defective.
How?
I tested out the phone when I make phone calls. Sometimes the screen doesn't go off.
Show that to me.
When you make a phone call.
Yeah, it has a little sensor here. And when you put it like near to the head, it just go off.
When you put the phone to your ear?
It's supposed to
It's supposed to turn off when you put the phone to your ear?
Yeah.
Why would it turn off? It needs. Why?
No, the screen.
Oh.
Because with your ear, you can touch any functionality on the phone.
Oh.
You can
So
put
what
on
you're
the
saying
speaker.
is that what he's saying is actually a built-in feature as opposed to a defect.
Yes.
Okay.
So instead of the screen getting disabled while you're making a call, it stays on.
Can you show me what you're saying? Can you prove to me what you're saying?
It happens on and off. And it's totally unpredictable.
Do you have anything from another authorized dealer that says that the phone has a problem?
No, I didn't.
Okay.
I haven't.
Can you recreate the problem right now that you're saying?
I'm going to try now.
Can you go over there and see if you note the problem? While he's doing that, let me talk to you. He comes in for the repair of the glass because his is cracked. And the first glass that you put in, according to him, is raised.
Yeah, it was a kind of raised because the screen that we ordered online, it was used. So when I tried to put it in, it didn't go through because it didn't come with the frame.
Okay.
So the
So
frame
then you
is
ordered him one that came with the frame?
yes.
And then that one was flush?
No, that one is working fine. He's using the phone right now.
Okay.
I'm not.
So your complaint is that what?
The phone is defective. When I'm on the phone,
But how are you going to prove that to me if you can't recreate it right
No, it
now,
works
and
the way
you
you do
don't
it.
and it works perfectly fine according to my bailiff, and you don't have anything from a repair shop that says it's not working fine? How are you going to prove your case?
I called the cops on the spot because he didn't allow me to show the owner. He said, if you have a problem, you come through me. and that's the way the phone is gonna be. So I showed the officer at the spot when the phone was acting up.
And did it act up in front of the officer?
It acted
Do you
up
have a
in front
police
of the
report
officer.
to prove that?
I have the police report.
Does it prove that?
It just states the complaint. It doesn't state that he tested it. He showed.
So you said something about there were scratches on the glass and that was part of your complaint about this too. Can I see that?
Sure.
Did you say any of that? Can I see the police report?
I told him that. He said, well, you paid for a used screen. Nevertheless, he charged me for the new screen $110. The original price was $80.
Wait, there's all kinds of scratches on this. Are you saying you got it this way?
That's the way he delivered the phone, yes.
With this enormous scratch on the left and this other enormous scratch here?
Correct, yes.
Yeah, and it's in the police report that the screen has scratches. Can I just ask you to take a look at the scratches and tell me, is that just to be expected because it's a used, I don't know. Tell me what your answer is.
Okay. Since it was a US screen, when I explained it to him, I told him it might have some scratches, but it's functionally working. The screen is perfect besides the scratches. When he asked me how much was gonna be the new screen, I told him that's gonna be too expensive. What I suggest you to do is...
How much was the new screen?
The new screen cost like $180. But the one that I sold it to him, that I put it on, I just put it $110. So he will save $70.
$70. All right. And now, according to you, he never told you that the screen was going to be scratched.
No, he never did.
Because he doesn't strike me as the kind of guy who would say, yeah, sure, I don't mind. He strikes me as a difficult man.
Okay, so big standoff between the repair shop and the customer. Who wins?
Repair shop owner.
Why?
Because the customer
Okay, she's so wrong. Who wins?
So the customer wins because there should have been a proper protocol in which the repair shop owner documented the damages.
Oh God, you're so warm here. How do you document it on the
receipt?
Yes! We're done. Going inside the courtroom.
The difficult client is probably going to complain about a scratch. Do you have paperwork with him?
Yes, I have the
where
receipt.
It says that the used screen may have scratches, and he approved that beforehand?
Yes.
May I see it?
Okay. Here it says use screen.
Yeah, I know, used.
Okay.
Used does not mean there are scratches on the phone.
Yes, I know.
Used means used.
But on the description it says it might have some scratches. And I showed it to him all the description, and he was reading it, and he agreed to that.
Did he show you the screen that he was going to order on the internet?
No, he did not.
But you agreed to buy a used screen. You weren't buying a brand new screen. You know that, right?
Well, I was under the impression I was buying a new screen. That's why I'm paying $110.
Why? A new screen's $180.
According to him, he initially told me $80 for
How about just the paperwork? Don't you have something from him that says, that he a used screen and he understands it may have scratches?
This is all I got, the receipt from him.
Right, and it doesn't say that he acknowledges that there are scratches on the screen. That would have been a better idea, right?
But
to have him, if you're sitting there showing him stuff and telling him you approve, right? It would be better to have him sign that he approves ordering that particular screen that has scratches. All right, here's how I find. I find the following. I don't think you're going to get away with having them refund to you the entire purchase price because you had a cracked screen and now you have just a scratch screen. I do, however, think that you haven't been able to prove that he approved of the scratches, in which case I would just put you in the position you were in beforehand and make them return your $110. You have what appears to be a working phone because you're still using it after all this time. You do not have anything from an expert saying that it doesn't work. And however, that phone does have some scratches. So in my infinite wisdom, brought to you from the Department of Rough Justice, both put your hands down because I'm done with both of you really. Rough Justice, I am going to order the defendant to repay a portion of the price back, and that is a verdict for the plaintiff in the amount of $50. That's my judgment.
Well, here's the plaintiff. How does $50 sound? Here.
Not good at all. Not good at all.
No? Why not?
Well, after having someone use crazy glue on your phone to try to fix it, I mean, now I cannot even get anywhere near a phone for $50. Not even a screen.
No. Well, you seem, you weren't entitled to sue for a brand new phone.
Well, the phone is defective. It acts up. It's not really the same phone that I brought him. So right now, I'm really inconvenienced for the malfunctioning of the phone.
Yeah. All right. That's the way of the documents that you sign? Right that way? All right. And so come on in here and tell me, what do you think of the outcome here after fighting your case in there like that?
Well, seeing it was a US screen, he wasn't supposed to get any back because the phone is perfectly fine working and the screen is the right one that goes on the phone.
Why do you think he sued for a brand new phone? What do you think he's up to?
He was trying to get a new phone because he dropped it and he damaged it, and now he wants a new phone.
Harvey?
Okay, here's the thing. If you've got an item that malfunctions and you go to court over the item because you say it was defective, videotape the malfunction before you go to court in case it doesn't actually work in court the way you want. At least you can have it on videotape showing the judge you're telling the truth. That will do it for this case. Litigants for the next case on the way into the courtroom right now.
Meet the computer you can talk to. With Copilot on Windows, working, creating, and collaborating is as easy as talking. Got writer's block? Share your screen with Copilot Vision to help spark inspiration, and use Copilot Voice to have a conversation and brainstorm ideas. Or maybe you need some tech help. With Copilot Vision, Copilot sees what you see. Let Copilot talk you through step-by-step guidance so you can master new apps, games, and skills faster. Try now at windows.com/Copilot.
This is the plaintiff, Lori Morales. She says she rented an apartment from the defendant, and it was supposed to be a smoke-free house. The very first night she spent there, she smelled smoke, and sure enough, the tenant across the hall was a smoker. Her son has asthma. The defendant lied to her. She had to move out, and now the lousy landlord won't refund her $2,800 in rent and security. So she's suing him right here, right now. This is the defendant, John Stamoulis. He says the plaintiff came to see the apartment 3 times, and when she did, he introduced her to this stepson who would be her neighbor, and he was smoking a cigarette. She knew full well she'd be living near a smoker. Is coming up with this cockamamie story now because she changed her mind, and he owes her nothing because she didn't give him 60 days' notice as required in her lease. He's accused of hiding something. The defendant has filed a countersuit for $1,400 for lost rent.
All parties, please raise your right hands.
Welcome back to the People's Court. Next case in the docket, the plaintiff says the apartment she rented from the defendant was supposed to be smoke-free, but it wasn't. Somebody smoked inside. Now, the defendant saying she knew the guy smoked. It's the case of I'm camel TO'd.
Thank you, Douglas. Ms. Morales, you are suing Mr. Stamoulis, your former landlord, for $2,800 that you want returned to you, that you paid to him for an apartment which, according to you, he rented to you under false pretenses because, as it turns out, people were smoking. All right. What did you rent out?
Your Honor, I rented out a 2-bedroom apartment.
What kind of building is it?
It's a single-family residence with 2 apartments adjoined by a shared hallway.
Okay, but you have your own kitchen, your own bathroom, your own whatever.
Correct.
All right, so what happened?
Well, I signed a non-smoking lease.
Right, your lease actually says no smoking.
Correct. So the gentleman, I asked him politely to not smoke inside of the residence.
Right.
He, in turn, said to me that he was going to smoke in the residence because it was cold outside. And then the smoke was coming back into the shared hallway that I had to go through with my 12-year-old son to get into my apartment doorway. Since it was a shared entry, we both had to go in and out through the same hallway. So that is where...
Where would you smell the cigarette smoke? Just in the hallway?
No, because it was coming under my doorway.
Well, that's what I figured.
Correct.
All right, so
Yes.
so you're actually smelling the smoke also in your apartment?
Yes.
All right, and who is the other tenant? My understanding is he's related to the defendant?
I believe it's somehow related to him
Okay.
through...
Stepson. Your stepson, okay.
Yes.
So when does she call you and say, I can't live here?
The end of November.
Okay, and why does she say she cannot live there?
Because her son, he can get the smoke, I don't know, but I never see her son.
Okay, how old is your son?
My son is 12 years old.
He's asthmatic?
Yes, I had to take him to the doctor. I have a copy of the medical report.
Where they, in fact, prescribed several inhalers for him?
Yes, he was wheezing.
And that happened on what day?
I took him to the doctor on November 15th.
All right. And did he ever sleep in that apartment again?
No, I took him to my parents.
You moved in on November 9th.
Yes.
So we're talking about right away.
Yes.
All right. Do you ever call him before the end of November to tell him we have a problem?
Well, what happened was I gave the gentleman a phone call and I told him we needed to speak. I then went and met him inside of his portion of the home.
Is this in the end of November or before the end of
No. I, spoke with him right away. He was under the impression that he had spoken to the gentleman about not smoking in the home because of my 12-year-old son. And he said that he would refund my check to me. And I said that, I had to go find a place to live because I had no place to go, that my son was going to stay with my parents, but then I in turn had to go find a new residence. And that was my month's rent and my month's security that I had.
Plus the trouble of moving again.
Correct. I had to pay. I had moving and storage fees. I had,
So you tell him that and he says what?
I have no problem. I'm going to give you your money back. In good faith, I gave the gentleman back his key. I vacated the apartment. By the 26th, I had a moving truck come. I had to find people to help me.
You got a new tenant right away, didn't you?
No.
According to you, he got a new tenant right away or no?
I have no idea.
Okay. All right. So he doesn't return your money. Does he ever tell you, listen, I'm not going to return your money?
It took me about 10 days of, I gave him a little break. I said, okay.
Okay, I don't need to hear about all that. I just want to ask you, did he ever finally say to you, I'm not returning your money? First, he gave you a bunch of excuses about I have to wait for this, I have to wait for that. Then he just said, look, I'm not going to return your money. Did he tell you why?
He just said that he didn't really give me any reason. He just said to me, I'm not going to give you your money back.
He didn't say because you didn't give me any notice?
No.
Okay. And according to you, you don't feel like you should have to return her money because she didn't give you any notice?
Yes.
Because under your lease, you can leave in 60 days, right? You just have to give 60 days notice?
Yes, but
you understand that one of the things that you warrant when you give somebody an apartment is that they're going to be able to live there. And this is a building that is on the lease. The actual address of the building is on the lease, and it says no smoking this big all the way across. So why is it the other guy gets to smoke in the house and then smoke up her no smoking premises?
It's different apartment, Your Honor.
I understand. And normally I would say to her, you know what? You don't have a right for your neighbor not to smoke. I understand that. This is a little bit different because it's an apartment in the same building and you rent out do you even have a CO to rent out? What town is this? Do you have the ability to rent it out to two separate families when it's a single family home?
I am retired.
I am retired is the answer to my question?
Okay, so the lease says no smoking. Somebody's smoking in the apartment. Can the person who doesn't smoke just break the lease, get her security back, and move?
Yeah.
Because?
If the rule is no smoking, then it's no smoking.
Okay, that seems pretty simple. Everybody agree?
I agree, yeah. They should be able to break the lease if they're allergic to smoke, if they don't want to catch cancer.
So if there's something in a lease that gets violated, the tenants can move out, correct?
Yes, it's a violation of a contract.
Fair point. God, she's good. Going inside the courtroom.
You know what I'm asking, though, right? Yeah. You know what I'm asking, right?
I have to rent.
You're treating it as a two-family home when it's a one-family home? Are you allowed to rent it out?
It's a one-family home.
Yeah.
But
in any event, let me just ask you, when she tells you I'm going to move because I can't, he's smoking in the house, do you ever talk to your stepson and ask him to stop it?
Yes, but Mrs. Lori know he smoked inside before she's come give me the money.
Really? She's got an asthmatic son. What are the odds that that's true?
She came inside and she's taking up everything. And she says, I like very much the apartment.
All right, and then you give her a lease with the address of the house saying no smoking.
No smoke and her apartment.
That's not what the lease says. The lease just has the address of the house.
Yes.
There's no separate apartment number for her. She figures no smoking. Fabulous. She's got an asthmatic son. This case is different from someone who says, hey, I don't want to pay him rent because the unit next door that someone else owns, the guy's smoking. Hey, you don't have a right to, you're living in an apartment. Yeah. But this is different.
Yeah, Your Honor. She came and she gave me $500. And we was around the apartment and I introduced to her my son and my son was smoking that time. That happened by 18
Was his son smoking when you met his son?
Not in the house.
Was he smoking outside the house?
He was smoking in the driveway, but he was not smoking inside of the home.
Did she meet him in the driveway or in his apartment?
No, his was on the entry of his door because I knocked the door and he came outside.
Did you ever suggest to him to just return the security deposit? At the beginning, you were just asking for the security deposit, right?
Like I said, I
yes
asked
or no? My questions are so simple. No one can ever answer them.
Yeah.
Right. And it's not until he refused to give you the security deposit you decided you wanted to sue for November rent also.
Yes.
Did he ever tell you, I'll just evict my son?
He said to me when I approached him about returning my money, he said, would you like me to ask him to leave? I said, the damage is done. When he's blatantly told me, I live here too, I could do what I want. And I didn't want to have confrontation with people. I didn't want to have to be in and out.
I mean, I see his side too, to be honest with you. You know, his landlord totally lets it. Does he pay rent?
No.
Okay. So, is he a grown man? He's grown enough to smoke. Yeah. Maybe he should pay rent.
He's not paying rent.
Why? Because happy wife, happy life? All right, that's between you and him. Show me the record from your son going to the doctor.
This is the first visit, and this is the follow-up check.
And was he already under a doctor's care for respiratory issues?
Well, he had gotten sick about the 13th or so, and then I brought him to the doctor.
He gotten sick with what?
He was coughing, sore throat, and he was wheezing.
Yeah. Under these circumstances, I think returning both the security deposit and November rent is appropriate. I'm ordering a judgment in favor of the plaintiff in the amount of the $2,800. As to your counterclaim against her for additional lost rent for the same reasons, the answer to that is no. Good luck, folks.
Well, here comes the defendant out here. Step right next to me here. You lose this case. What's going through your mind coming out?
I don't want to say anything because I like that, Your Honor.
Well, it wasn't her fault that you got yourself in trouble here.
No, because Mrs. Lori, my son was smoking, and by 28, she gave me the rest of the money.
Didn't you know that there was going to be some trouble down the road with the smoking when you know she didn't want any kind of smoke around her or her son?
It's a different apartment.
Well, you don't have to smoke right in somebody's face to be affected.
Anyway, I don't want to say anything. I like very much the Your Honor.
Okay. Okay, come on in here. Are you satisfied how this comes out?
Oh, yes.
How bad did it get?
Well, you can't rent somebody something that's, not really the truth. And I'm very happy that I'm getting all my money back. And
how about the health of the young one?
well, he's okay.
Yes?
He's good, and, that's really my main concern. It wasn't really fair to either one of us, and he's my main priority.
Okay, over to Harvey now.
Okay, I cannot tell you how many of these cases we've had over many, many years where tenants and landlords have these oral leases, and the fact is, in most cases, they're valid leases. The problem is when you have this kind of a dispute where somebody says the landlord said one thing and the tenant said another thing, the only way to really fully protect yourself is to get it in writing, and in this case, that's exactly what happened, and look at the rights the tenant had. Getting in writing is everything.